Good evening and welcome to Land Title Talk, where we encourage you to text in your questions or comments at 904-501-4481, 904-501-4481, and we'll address your questions on air if Rusty stopped talking, but we'll see how it goes. Also, you can email us at Stephen@golandtitle.com. That is Stephen, Stephen, at golandtitle.com. As always, we have our special guest, Rust-Oleum, also known as Rusty Collins, or if you want to be official, the Law Office of J. Russell Collins, affectionately known as Rusty Law. And as always, Julie, we appreciate you being here, keeping us in line, Julie from Land Title America. Today we have a very special guest, my dear friend Josiah Ronco, Josiah Ronco from AcreVault. So Josiah, tell us real quickly about AcreVault. What do you do?
We primarily buy and do minor developments and small, like, forced appreciation jobs on rural vacant land, mostly in the Panhandle and northern central Florida, but also some stuff in North Carolina, Georgia, Alabama, Tennessee. But Florida is our, like, 95% of our business.
How long have you been doing
that? 5 years.
5 years.
Yeah.
And in that 5 years' time, you've seen, how many transactions do you think, if you had to guesstimate, if you had to throw a number out there, how many transactions have you been involved in the last 5 years?
Transactions? Like,
now, see, a nice guy would have warned you. I was going to ask you that.
No, that's good.
We don't like giving you heads up.
I'm going to guess, because we have a lot of, it's like we buy it, maybe we subdivide it into, say, 8 lots and then sell. I don't know, maybe 500.
That's amazing.
Something like that.
That's
probably about, I'm going to say 500 or 600, give or take.
So give us a little bit of knowledge on your pre-life before you started real estate investing. What were you doing before then?
Well,
it makes sense that we go from the job that you had into real estate. They coincide so nicely.
Are you joking?
Yeah.
Well, so
I am joking, Josiah.
So my job, so I got into the music industry. Really, I was still in high school. I was homeschooled, right? Grew up homeschooled, did dual enrollment I'm from Tampa Bay. Did dual enrollment, got a job at the State Theater in downtown St. Petersburg as a stagehand. When I think I was 16, 17, had a job with Sony Music as like a street team rep, like a part-time job, handing out flyers and CDs and hosting after parties at record shops. It was fun. Yeah, like sampler CDs and stuff, even cassette tapes, some back then, but,
how old are you?
38.
Okay.
Yeah. Yeah. Got a job doing that. Eventually, like, long story short, got into the touring music industry as a guitar and keyboard technician, or backline technician. It's kind of the overarching term. Started touring, traveling the world. That was great.
I mean, that's such an interesting transition.
Well, it was.
I mean, you're out handing CDs, and all of a sudden now you're a tech. That just can't happen by accident.
Well, so it was like having the job at the State Theater. As a stagehand, it's like you're helping load in when the artists would get there, their crew would get there. You're helping them unload
and you're
equipment.
Getting to meet these bands and these artists.
You're meeting not maybe not as much the bands back then, but meeting the crew. And then that was when I realized, like, oh, this is a job where you can get paid to like go on the road and take care of people's guitars or keyboards or drums or whatever. I was like, that seems really cool. Like, I would love to do that. And then I had a buddy from a band from Lakeland, Florida. I think they're still a band. They're called Copeland. Great band. Had a buddy who at the time was the bass player for that band. And I heard through the grapevine that they were looking to hire a guitar tech, called and was just like, hey, I'm interested.
Did you know anything about guitars?
I could play a little bit, and I knew how to like restring a guitar. I knew how to restring a guitar.
You were a player then?
Not really. I'm not a player. Like,
you could play.
I could strum chords.
Okay.
I wouldn't be able to keep up with a band or anything like that. But I basically called, wanted to get a job with them. Long story short, again, they basically they were like, we can't pay you anything. And I was like, they were like, so we're not gonna hire anybody for this role.
Such a great
They
job.
said basically we're not gonna hire this role. We don't have the budget for it.
Right.
I called him back the next day. I was like, I'll do it for free, man. Just bring me on the road.
Wow.
And he was like, all right, we can't really turn that down. So then went out for free event. They started paying me though. They took great care of me, just to be clear. But and then that was my foot in the door. And then from there it was like every job it's all word of mouth for me.
Wow.
And I'd say that's the case for most people in the industry. Is just very rarely, I think, are people getting jobs from their resumes. They're getting it from word of mouth.
And you did that for how many years?
Basically 16.
16 years.
Yeah. So
Wow.
basically
On the road.
2005, late 2005 to 2021. My very last show, my wife just reminded me of this actually. I think it was September 4th or 5th was the 4-year anniversary of my very last show on the road. Well, that was the thing. So COVID hit. Tour got canceled for the rest of the year.
Right.
That was how I started doing AcreVault, was because I started investing in real estate in like 2000. I would count it when I bought my first house because I rented out all the bedrooms. In 2009 when I bought my first house, but really started investing in real estate a little bit in 2012. And then that was just always kind of like a side thing. The plan was like, oh, this is like kind of my retirement plan. And then yeah, COVID hit, got laid off, tours canceled. It's like, what am I going to do? And I had heard about land flipping on some podcasts and everything. And I was like, let me try this out. So I started sending out I got a phone number and a little website and everything, started sending out direct mail, and people started calling. And I was like, oh, wow, people actually respond to direct mail. This is amazing. and then we went back on the road in 2021, but very quickly I was just like, my heart just wasn't in that anymore. And it was time for me to get off the road anyways. At that point, I got married in 2016. Been with same girl since 2011. And I mean, she was very patient with it, but was also kind of like, all right, how long are we doing this where you're gone for 9 or 10 months out of the year? You know?
So when you started in the real estate in AcreVault,
Yeah.
did you start off with AcreVault? When did AcreVault become into existence? How quickly after you started doing real estate?
I think, 2020. I wasn't.
So you said, I'm going to do this. AcreVault's my name.
I think the first name I went with was, I think I called it Live Oak Land Buyers for a while. And then I was like, that's too long. I don't like it. And then I had actually a guy I worked with. I worked for a band for many years called One Republic.
Oh,
The
everybody knows One
great
Republic.
band. They're an amazing band.
We need to probably have you list all the bands you work with. That's not.
It's a
you
pretty good
say that
list.
like that's some small band.
Well,
That's a very popular band.
Well, I don't like to assume people know, but probably everybody knows at least 10 One Republic songs. Like if you've been in a hotel lobby, a Home Depot, a grocery store, like you know their songs. Actually, it was the AV guy, this guy, Brody. I was like, can you make me a logo? And I'd thought of the name AcreVault. I was like, I like that name. And I was like, can you make me a logo? And he was like, yeah. And he made a logo and I loved it. Loved the colors and everything. And so that was probably 2021. I switched then our DBA to AcreVault.
So how long were you a single show, a single act? How long
Until
did it take?
2022.
Just a year?
I was slow to hire. Well, August of 2022.
Okay.
Hired
We sort of had a
Cheyenne.
conversation about that, didn't we?
Yes.
I remember us having that conversation
Because I was
back then.
swamped. I was overwhelmed.
Right. And
Yeah.
then since then, you now have how many employees?
We have, as far as like we got employees. We have a lot of 1099 people that work remote, flexible schedule kind of
You
thing.
have full-time employees, six
Six or seven full-time now.
full-time.
And then
So
it's
it's
like
really-
3 part-time.
This business has really grown for you.
Yes.
Why do you think your business has? I've got an idea as to why I think it's grown and why I think you're successful, but I want to hear from you, and then I'm going to give my 2 cents.
Why do I think it's grown?
That cannot be a hard question, Josiah.
I mean,
You-
it's just like we put in the inputs to grow it. You know, it's marketing. We spend money on
I think it's
marketing.
very simple why your business has grown,
Why?
because you truly do care about the people you're helping,
Yes.
and it's very obvious. And how
Rusty
you-
just heard me on a call with somebody I really care about
Yes.
that we're buying property
and you
from.
really care about
Yeah.
the people, and people get in situations to where they don't have a way out.
Yeah.
They don't have the resources to get out. They're stuck in a corner. You come in and you provide them opportunities. And you do that by investing in their property and giving them a way to have a decision. They don't have to sell to you.
Yeah.
But they're stuck there. Their taxes are coming due. They can't pay the tax, or they have legal work. They can't pay that. Or they have hurricane repair work that they can't get to.
Saw a lot of that.
Or homes that are damaged. They can't get insurance. They're getting foreclosed on. All these things, it's amazing what you do for these people. You come in, you help them out. Yes, you make money because you're taking a risk. There's no guarantee what you're doing to help them is going to benefit you and maybe where you can help the next person. So you've got to be successful to be able to help the next person.
Yeah.
But that's why you're successful, by virtue of that model. And I think your business, I know you do a lot of direct marketing. You're out there, you're helping and letting people know that you're there. But you've got a lot of competition, and unfortunately, the competition is not as good as you. So I think the word of mouth, and that's helping your business grow too. But it's amazing to have watched as your business has evolved. I've watched it actually. I was with you pretty early on, and see it evolve to when you had one person, now you have two, and then you got more than that, and it's just exciting to see it.
It is
maturate. But
thank you.
So, Rusty, what's going on in your world?
Nothing.
Good. So we did something, and I'm doing this a lot now, Rusty. I'm giving you heads up.
Yes, you are.
On what we want to talk about, which is just not as fun. I really like just surprising you with the topic. But the problem is you get so ADD and you start focusing on looking things up. So I figure instead of doing that on the show, I'd give you a chance to look at something in advance. Josiah, you know what we're going to talk about.
I hope it's what we talked about earlier.
Yeah. It's the situation where you bought a piece of property. What magical thing did you find on this property? And it's not like you didn't know it was there.
Yeah, we knew what we were getting into.
All right. So what did you get into? What did you find on this property?
There's a cemetery on the property.
How big?
It's not like delineated specifically on the survey, but I would say it's probably somewhere between half an acre and 1 acre but this is a 40 acre. We have a quarter section.
Okay.
I'd say it's an acre or less.
It's not like unmarked graves. There's tombstones.
There are some unmarked graves. There are quite a few unmarked graves, and somewhere I think there's no tombstone anymore at all. But then there's I think the most recent marked grave I saw in there was like 1886.
That's the most recent.
I think the oldest was late 1700s, early 1800s.
Pretty, actually, somewhat cool.
It's pretty cool.
Yeah.
Yeah.
And just to get to the end, you had no problem selling this property with people knowing the I want to call it the gravesite.
Well, actually, it's funny. I signed the deed today when I was in the office.
Oh, really?
Yeah. It's closing in a couple of weeks.
Okay.
We actually had a bidding war for this property, which was surprised because I was a little nervous. I was like, what are people going to think about the cemetery? I don't think anybody's viewing as a positive, but I think the rest of the property is so nice.
Right.
That, and it's so big. It's 40 acres. Okay. The cemetery is a little fraction of that. And it's in a good spot. It's not like right smack in the middle of the property. It's not where you would want to put a home site. It's not like blocking your access or anything like that.
So, I mean, if you were to keep this property per se.
Yeah. Which I thought about because it's awesome.
What Rusty writes, I mean, it's such an interesting dilemma. There's so many things at play here because back in the day, I mean, to have a cemetery now, there's license, there's things you have to do, right?
Correct.
You just can't start burying people in your backyard.
I'd like to be able to do that. Got some flat estate property might be good for.
So, but you can't do that anymore.
No, you can't.
Right.
You can't legally put grandpa in the ground out back.
You can't, even if you own like a whole bunch of land, you can't do that. Or like if you have.
Can you get caught?
Well, like let's say you own a whole section.
Like growing marijuana in the back where they can see where they fly over. Okay.
Like if you own 640, if you owned a whole section, like you have a ranch, like can you start a family plot on your land?
I don't know that there's I don't know whether there's a prohibition to that or not. I know there's some obligations if you do it.
Well, back in the 1700s,
We didn't have too many cemeteries
you
except in town.
you buried your family on your land.
Yeah.
It is probably pretty unnerving on some properties that we start digging around on, to where you probably are disturbing some places that you just didn't know were there.
Yeah.
Back in those days, you didn't really, there weren't too many cemeteries. I mean, unless you're in St. Augustine, of course, they have the big cemeteries there. But you know, you're out in the country, you know, by the time.
Well, we've seen cemeteries in Elkton, and we've seen them in Hastings.
Yeah.
And, I mean, it wasn't like it's completely uncommon.
Yeah, but in your own backyard. And that's what really this is. This was not a community cemetery.
No,
this
this
was
is
a family cemetery.
This is a family. I mean, most of these people have I don't know, I probably shouldn't say the last name, but most of them have the same last name. Yeah.
So,
because the heirs or the descendants still, there's a mailbox next to the cemetery, like a plastic mailbox with a 3-ring binder, kind of guest book, but it's got it's pretty cool. Like there's photos going way back of people visiting. I think it's maybe part of like a family reunion thing they do every few years and visit.
Is it on the Find a Grave website?
That is a really good question. I have not looked up.
Look it up.
What is it called? Find a grave?
Well, but you'd have to know somebody. You'd have to know the name of somebody who died.
I could find some of the names and we could look it up.
If you can do that, if you can find out if any are patriots, because then you get additional help with the care of the cemetery.
Well, there's a veteran of the Creek War that's buried there. So that was 1813 to 1814 was the Creek War.
Pretty crazy.
Yeah.
So the interesting thing about having this site on the property, it's not right on the road, is it?
No.
It's back.
It's back. Probably half a mile off the road, because this 40, our access is an easement, like a 30-foot easement.
Okay.
Coming back off the road, it's probably at least a quarter mile, maybe more like a half mile off the road.
You have this gravesite
in the woods. It's basically in the woods.
In the woods.
It's literally in the woods.
And you have what type of rights? And this is why I wanted to give you a heads up, because I think it's an interesting topic. What rights do the descendants of the deceased persons have to access that gravesite, that cemetery?
And there's no, I believe, because I looked at the search package, I don't think there's any
easements.
There's no easement filed or anything like that.
Or any rights of anybody.
And it's not like there. Some cemeteries, we've bought property where there's not really a cemetery on it, but where, let's say there was one we bought where it was like 15 acres and there was like a 1/4 acre cemetery on it, but that was like cut out.
Less than accepted or wasn't included.
Like even if you looked at the GIS, it was like that little 1/4 acre was just like a landlocked 1/4 acre.
Right. Probably had an easement to it though.
I think in that case, I think there was an easement.
Right.
But like I said, in our case, it's like, I mean, we own it. It's on the survey. There's no easements of record. I assume they have some kind of right to visit the property. Or visit the cemetery. I don't know.
Talk to us, Rusty. You've got that look. You have an answer. You're waiting. Okay, tell us.
According to what I found, you can actually list the private cemetery with Find a Grave. And then you can list everybody on there. And you can make memorials and everything listed on there. You may need to provide access to people to visit the cemetery if necessary. And I also looked, and you can have a private cemetery 2 acres or less.
2 acres or less?
Yes.
And that's in
on
Florida?
Your property now.
Wow.
Yes.
You got to get like a permit, I would assume.
Do like local zone. It says you got to check local zoning, and you have to do a couple things like burial transit permits and stuff like that, and be open to inspections.
So there's a permit for that.
Yeah, but you can have 2 acres or less to have your own cemetery on it. Yeah. Mm-hmm.
How about that?
How about that?
Cool.
All right. Tell us what you
Okay. The relatives and descendants of any person buried in a cemetery shall have an easement for ingress and egress for the purpose of visiting the cemetery at reasonable times and in a reasonable manner. The owner of the land may designate the easement. There you go.
So they have rights.
That, yeah, if you were smart, you designate where that right
You
is.
go ahead and create an easement for it.
Yeah, I would create at least a way for them to know how to get there.
Mm-hmm.
Right.
So you don't need them going through the middle of something.
Yeah.
And,
Well, you know, and I go the liability route.
Well, what liability are you worried about?
Well,
It's a cemetery.
when they go,
Your backhoe.
not that I want anybody else buried there. I'm saying the liability of people going back there at night, or people going back there. All of a sudden, somebody breaks their leg. What happens?
Breaks their leg on what?
A tombstone.
Well, then they shouldn't be tripping over tombstones.
Gotcha.
Okay.
But the insurance, what's going to happen?
Well, I think everybody needs liability insurance.
Yeah.
I mean, you
Which
would
we
in that
have,
case.
yeah.
Because you
Yes.
don't want to have to defend it. I think you'd win. Because
What do you mean you'd win? The freaking guy who breaks into the house and to steal it and dies before he can get out because it was being fumigated, sues the owner of the house, and his heirs win because it wasn't posted properly.
did it go to court or did it go to the end of it for a
You know,
judgment or
we
was
would
it a
have to
settlement?
look it up. It may have been settled, but
Okay,
this
'cause
is
the
crap
cost
like
of
that.
litigation, that's why people settle.
I get it, but I mean the liability is a real
That's why you have liability insurance.
well. I think that's a smart thing
But
because
again,
you do have cases like that, and I would like to look that case up. It was a case in California. Guy was breaking into the house and it was being fumigated. It wasn't
For
properly
termites?
posted. Yes, and the guy
He died.
I am not. I don't
Did
mean
he
to
catch
laugh.
the fact that there was a tent over the house?
I don't mean to laugh because it's not that funny, but it's just funny. I mean,
What's a Darwin Award, right?
Yeah. 1,001 ways to die.
Yeah.
it's a Darwin Award, but still, I mean, but they were. I should say that I believe it went to court and they lost because it wasn't posted properly. Not that it would have mattered because it was late at night, and the guy wouldn't even seen the sign, but that's what they got him on.
Hmm.
Well, about what you're talking about, the statute also says if the cemetery is abandoned or otherwise not being maintained, such relatives and descendants may request the owner to provide for reasonable maintenance of the cemetery, and if the owner refuses or fails to maintain the cemetery, the relatives and descendants shall have the right to maintain the cemetery.
Wow, that's interesting.
So if nobody's mowing it, they can mow it if they want to.
Interesting.
So you have people who have the right to take care of it. We do have a special thing for cemeteries, I guess, and but we can't be transporting. They really don't want you to dig up the cemetery and.
No, there's a movie.
Yeah, there's a movie.
There's a movie about that. Yeah,
You don't wanna do that.
Too keen on that. No.
Well, I just move the headstones.
Yeah, that would work. Not, but so it's interesting some of the things you run across. Are there any fun stories you'd like to talk? Because you don't have to. I mean, the point is this: you do provide because you got to think about it, Josiah. A cemetery on a 40-acre tract would deter most people from most people wouldn't even look into to what it would take to fix up the property, make it presentable. You do.
Mm-hmm.
You would.
Mm-hmm.
And that's the risk you're willing to take to help people who need to take that next step in their life, which is pretty commendable, my friend.
Thank you.
I know it's a business, but there's nothing wrong. Doctors make money too, right?
Mm-hmm.
I'm not comparing you to a doctor, but you get the point, right? You're providing a service and you're making money doing it and being successful at it, and your business has grown because of it. So it's quite interesting. What other things do you run across that are quite interesting?
We clean up a lot of it's almost like I feel like 90% of the properties we buy have a absurd amount of garbage and trash on it.
I see your video and you got the big,
Yeah.
do you own that equipment or you rent it?
No, we rented that.
Okay.
No, we bought some equipment we did not own it for very long. We basically ended up just flipping some equipment to a buddy of mine who started a land clearing and
Right.
garbage cleanup business. Cause I was just like, I don't actually want to own all this stuff and be responsible for maintaining the tractor and
Right.
keeping it running and everything that comes. I'd rather just hire my buddy Jeff or whoever
Get it done.
to do it. Yeah.
So I know one of the things you run across a lot is estates.
Yes.
Working with people who are
A lot.
in the quagmires of estates. Rusty, when does, and we've talked briefly about this on this show, but I want to talk about it again. When does a person inherit the property? If let's just, I hate to be morbid here, I'm not married and you're my brother and you're my only brother. I die. Who owns the property?
Oh, assuming you don't have any parents that are alive.
No parents that are alive. You.
If it's your homestead, yeah.
Okay. What if it's not my homestead?
I will be the one that inherits
But
it.
don't you inherit it at my death anyhow?
Subject to creditor claims.
Okay, subject to creditor claims. But you do inherit it.
Yeah.
Okay. After a person has been dead for more than 2 years, what would you say?
Well, then we do summary administration, and we're not worried about creditors at that point.
Okay.
And now you can, if you have several heirs, the heirs themselves, we're not talking about homestead. We're talking about just regular other property or other assets. The heirs could decide that Johnny gets everything if they wanted to.
Okay.
Okay.
But don't they have to do that through deed?
No.
So talk to me about that.
Okay. So
because
What's the difference with homestead? Is intestate succession handled differently if it's homestead property?
it can be. It depends on what you're talking about.
But
Okay,
see,
so
but-
homestead property, if you have minor children
Mm-hmm.
and are married, you have the option to devise your homestead, I think, to the parent, to the spouse.
To the spouse.
Okay,
Like not where the kids get nothing.
right, but that's if you
Okay.
have. If you, oh heck, I just
You better look that up.
I keep it in my head.
I think you're wrong.
I just learned something today talking to him about another
He's not
file.
always right.
Well, I thought that, how do I, okay. I thought when you're talking about intestate succession,
Mm-hmm.
it's always staying in the bloodline of the decedent. But then I've also heard you say many times title passes at the moment of death.
That's my story, and I'm sticking to it. But
That's
he's about to mess up my world.
He was telling me, no, I'm gonna make up some names here. If Susan died in 1965 and her husband's already dead,
Mhm.
and she had 2 kids.
Mhm.
Boy, I get so confused
The
trying
2
to
kids get
talk.
it.
The 2 kids get it. But if one of those kids,
Predeceased,
oh, that's what it is. If one of the kids predeceased, then their kids
their kids
get their share.
That's right.
But what he was saying is if so let's say Susan dies, her 2 kids are alive, they're both married.
Mm-hmm.
And then one of those kids dies like a year later,
Mhm.
and they were married at the time of their death, their spouse gets that share.
Yes.
I thought it goes, and maybe it's different in other states because we've been doing some of these.
Well, every state is different.
Like I think in Texas, there's no situation where intestate succession goes to like a spouse of a descendant of the decedent.
What you have to understand, though, when we're doing the stuff that's after the fact, okay? 'Cause
Right.
The person we were
30
talking
years
about-
later.
Yeah, so
Yeah.
the person died in 2005,
Right.
okay? And then the person we're talking about that has the spouse died in 2010. Those rights on an intestate succession were established at the time of the death of the first person, right? The parent,
Mhm.
grandpa, okay?
Right.
Now,
So grandpa died in 2005.
in 2005. Husband dies in 2010. Husband has children with spouse. Husband has children with wife. Okay. And neither one of them have any children that do not come from each other.
Right.
Okay.
Right.
So that's the key.
Mm-hmm.
Spouse, and when I talk about homestead,
Mm-hmm.
spouse takes.
The wife.
The wife will take the
Right.
will inherit.
So in that case, it's
Because they were married.
It's basically going kind of like, well, it's not out of the family tree, but
Well,
it is.
But here's the
Because-
thing: the
because-
kids, but the children of the wife,
Right.
or the children of the deceased husband, they inherit from the wife when she dies. Now she
but if
can
you want to
sell
make it fun, if grandpa dies, husband inherits, husband dies, wife inherits, wife has, husband never had any children, and then wife dies, she has no children.
It goes up her. It goes,
Goes
to
back
her.
to her.
It goes up her family tree.
Her family tree.
That's wild.
Totally
so now you
jumps.
have two. That seems
That's
crazy
why
that it
incest
works out.
works out so good. So you keep everything in the same family.
Incest,
Unless you
intestate
have
succession.
trusts that say
Well,
when
you can do other
someone
things. We're talking about
passes, it doesn't
intestate.
go.
We're talking about intestate
Okay.
successions. We don't have a trust.
We
Okay.
don't have a will.
No, I'm saying, but
And
if
we're
you
not
had a
talking about
trust, you could
homestead.
say it doesn't go over to the spouse. It goes back into
As
the
long
family.
as it's not homestead. So answer
If
me the
it's
question.
homestead, if you are a married person and you have well, you definitely have a spouse if you're a married person. Okay.
If you're married and you have a spouse.
One would hope.
and you have homestead that your spouse does not own with you,
hmm
the only thing that will happen, it doesn't matter what you put in your will, is that your spouse will get a life estate and your children will get the remainder.
Thank you.
Okay.
You were
Life
wrong
estate.
before.
That's correct.
Okay. Did you hear that? He was
So-
wrong before.
I'll be wrong again later.
I doubt it.
So if you,
So own everything with your spouse.
Thank you, because you're about to mess me up talking that way. So if it's Josiah, if it's homestead property,
yeah,
okay, you've got the husband who owns the property.
yeah,
He's married.
mm-hmm,
They've got minor kids.
right,
He dies.
mm-hmm.
Wife gets a life estate. Children get the ownership.
This is if the kids are only their kids.
Yes.
No, that doesn't matter.
Yes.
If he has a minor child,
It's his minor children.
his minor
Not-
children,
Not hers.
right? But if he has a
If
minor
he's
child,
not, if those children are not adopted,
I understand.
Okay.
They don't inherit. They're not.
They
they're
don't
not,
inherit.
They're not
it
heirs.
is his children only.
Right, but as long as his children are minors, if the spouse has other children, they're not minors, then that changes things. He can devise to his wife. Oh no, excuse me. If he has minor children, he can't do anything.
No, he can't do anything.
Right.
Right. So minor children make it to where your hands are tied on what can happen. Now, if everybody's adults, that's
You
different.
can do what you want.
Yeah, you can do a will and
And if
will it
you have
anybody you want.
a child, you can, and you don't have. If you have a child from that doesn't include, if one of the spouses has children that don't come from the marriage, then without more, the spouse would get a life estate with the child getting remainder, or the wife can elect to have a 50-50 relationship with it on a homestead.
In other words, call your attorney.
Yeah.
Better yet, don't own real estate without your spouse.
There's a lot of truth to that.
Mm,
Tenants by the entirety is a powerful thing.
yeah.
Yeah.
Which brings me to the point of congratulations.
What?
Oh.
What does that mean?
I don't think we're really announcing yet.
Oh, okay. I will say anything.
Somebody kill a rabbit?
Somebody killed a rabbit.
We're not announcing that the deed is not yet complete.
Yeah.
Not notarized yet?
No. So I want to talk about,
That's so
because the question that comes into play is, when does a person inherit the property? My one of the things that I think you and I have discussed over the years is that when a person dies, especially intestate, let's just keep it intestate for right now.
Mhm.
The heirs inherit at that moment, subject to
rights-
creditors' claims.
Right, their rights are established at that moment. However, they now with the heirs could do some monkeying around with it if it's not homestead.
Okay.
Even on a summary administration, you can say, "Hey, you get that house, I'll get this house," okay, or we'll just give all of it to you. So that's fine. The heirs can do that if they all
What's
agree.
the official terminology for that?
Screwing around with the heirs, I don't know.
There's another word for it. They rescind, or they.
Oh no, we're not talking about saying I died first.
No, I'm just saying that.
If you disclaim what you're doing,
Disclaim is
if
what
you
I'm saying.
disclaim, you're saying I died first.
You're disclaiming your
What happens
interest.
then if you disclaim?
Okay, that disclaimer. So
If
I
I
get
die first,
that.
guess what that
I
means?
get that. Okay.
My family gets mine.
Got you. So disclaiming is different than what you're talking about.
Right. So I'm talking about if we have intestate
And I didn't
we're
mean
doing
to-
summary
I didn't-
administration.
I didn't mean to get off on the disclaiming, but I forgot about that part.
Right.
That if
That doesn't cut off your spouse and your kids. That just means you died first.
so disclaiming means we're going to act in this estate as if I'm dead.
Right.
Gotcha. Okay. But you're saying that in the estate, I can say I don't want that property. You can get that property. I'll get this property.
Right.
And the reason I asked this question.
That's summary administration. You guys, the heirs can all agree what they want.
Okay.
Okay. And then if you have a full
See, I would want deeds from people.
that's when you have an order that says everybody agreed to this and this is what happened. That's what the judge says.
Yeah. You know, I've had
You
some
don't believe
judges-
the judge?
Well, you know what, Rusty, how many times have I seen a judge sign off on a probate or summary administration on homestead property? I disagree with that.
Well, but okay, but we're talking about homestead.
Because that's my point. When is the judge wrong? I have several instances where judge was wrong.
Well, they look at it if they do a summary administration instead of an order determining homestead, and the property went to the heirs at law like it should have, it's probably a no harm no foul situation. But if you have a summary administration on property that was homestead and
so-
it doesn't go out to everybody as it should have, and it's intestate, that's a problem.
No. Well, here's the example. We have a personal representative assigned to a homestead property. We have 3 heirs. Okay,
Okay,
you with me?
are they going to sell the property? Or what are they doing with it?
The personal representative sells the property and puts the funds in the estate.
And that's because he wanted a piece of the action.
I get it. But the problem is, I don't have deeds from the 3 heirs.
Well, then I would want, if I knew it was homestead, I'd want the deeds from the 3 heirs.
Okay.
If
Now,
it's
I
not
have-
homestead, you wouldn't care about deeds from the heirs if we're talking about a formal administration,
Right.
Correct.
If I have a
because you
personal
only need the
representative-
personal representative's
If I have a
deed.
personal representative sign off on a deed, I'm going to be chill like Bill. Okay.
Yeah.
Now,
But
here,
when I know it's homestead property and I get some attorney who wants to do a formal probate, we have a personal representative, and that personal representative is signing the deed. And I look at that in my title search knowing that I have 3 heirs. I have a problem. Would you agree?
I agree.
Okay.
And I know that it happens way more than it should. I have seen a situation where it made sense to do that with a personal representative because we want to convey good title. But it was a specific set of circumstances where you've got 3 heirs and one of them can't be found. Okay, so all we're doing is we're converting that property into money. Because one thing's for sure, if they all 3 got it and then they wanted to sell it and one of them couldn't be found, you could do a partition action and force the sale. It just costs more. So it gets to what's the end result, and then you got somebody who's holding that money for them so they can get the money when they find them. So the person that gets the money will get it. They'll get the benefit of the homestead. And that works.
Can't we get an attorney ad litem to sign on behalf of that third person that can't be found? I think that's the better way to do it. We're talking about an individual right. Title's a magical thing. Would you not agree?
Oh, it's an important thing. I don't know how magical it is.
It's
but
magical to
important.
me.
Okay.
Okay. Title transfers. The guy dies, homestead
Cute.
property, instantly the heirs.
It becomes their interest. And-
Right.
Right.
So I'd want a deed from each one of those. And if I can't find one person, then get an attorney.
But
ad
in
litem.
reality, though, what's happened is the judge has taken on that role a little bit because they're saying, you get the money. Okay? We can't find you. If we had an attorney ad litem, guess what? They can't find you either. Then what?
Put the money in the registry.
Well, the attorney ad litem would end up with the money, and then if they can't find them, they're going to do a sheet it to the state. So,
Right.
so if we let the personal representative do the same thing, we get the same result.
I get it.
And I don't know if other judges would do it, but I remember Judge Trainer on at least one occasion said, let's just do it this way to make it work so we can get the property sold. And
I mean, I
there's
like
no
that.
harm, no foul.
I like
Okay,
that.
because we're making sure the result is what it should be. Okay, that was the goal. And again, what's the reason for these rules? Okay, the
To
reason
protect the
protect the
the
homestead
heirs. Yeah.
and protect the heirs. So I think there may be some limited circumstances where you could do it like that. But I do also think there are way too many situations where the personal representative is using the homestead as an asset that they can pay bills with, or they can pay themselves with.
Right. And I have a real problem with that.
It happens with more attorneys than it should.
So in a deal where we have heirs, a summary administration situation, and actually this is not a summary administration, the specific situation I want to talk to you about. It was the homestead property of the person. Okay, they did live there.
Okay.
They've been dead for...
It was the homestead of the decedent.
Right, the homestead of the decedent. And they've lived there, I mean, they lived there for a long time, but they've been passed on for maybe 4 years, okay? So what happened is, and I'm trying to get the genealogy right, there were 3 heirs, okay? One of the heirs had already died, so, and they had 2 children, okay? So we technically have 4 people entitled. Would you not agree? Even though there's no summary administration or determining homestead done, you would say that we have 4 people entitled, right?
We have it's past the 4 people.
Okay. Even though there's been no order determining homestead and no summary administration on the
Right,
land.
because you don't have any judicial order that says when that person died, this is what happened.
Okay.
That's all that an order determining homestead does, is say, back when the person died 3 years ago or yesterday or whenever it was, title passed.
Okay. So we have an investor, not you. Okay.
Nope.
I did talk to you about this a little bit today. It's one of the deals.
Mm-hmm.
And what we had is we had this investor, Mr. Rusty, get a quitclaim deed from the 2 heirs of the 1/3 interest person. Okay.
Why did he think he had 100%? He just didn't do the genealogy very well there.
I don't know if he didn't know he didn't have 100%. Is that English?
Yeah.
Was that
no,
a nice
I think I'm tracking. Yeah. Okay.
I think he may have wanted to say, hey, I'll say you.
Throw it against the wall and see what sticks.
Right.
Yeah. Okay.
Something that you wouldn't do.
I would not.
No.
Yes.
This I know. But he got a quitclaim deed. Okay. From the 2
of the 3.
2 of the 3. Even though the order determining homestead is not done, and even though the summary administration is not done on the person that died, would you not agree they had interest?
Yeah, they had an interest.
So if they sign a quitclaim deed for that interest, this investor does have 1/3. Would you not agree? Even though it's not a warranty deed.
Okay,
Because
so
we people like we title people.
did we say that one of the 3 people that inherited died and he had
Yes.
2 heirs?
Yes.
Okay, he has the 1/3 interest. Now, it's not been confirmed yet by a judge.
Not confirmed, but
yes.
we're pretty good about the facts here. We're pretty confident.
But if you're looking at, does a quitclaim deed work instead of a warranty deed?
Yeah, see,
Can
that's
you
the
force
question.
but
But the
they
quitclaim
have
deed
the
is
interest.
well. The interesting thing is, Josiah, and you know this, and our listeners know this because we've talked about it before. A quitclaim deed is giving all interest you have, if any.
Mm-hmm.
Right. And here's the problem though, is if I get a quitclaim deed from you today and then tomorrow you get proper title, I got what you had today, which was nothing.
So that's the problem.
And
Yeah,
if I have
but-
a warranty deed
but
from
this
you
is why I'm
today,
arguing
then that passes through.
That
right?
does pass through. So always the better way to do it is to get a warranty deed from these heirs, so that when we do later on do the summary administration, do the order determining homestead,
Well, wait a minute.
And is that what's the term?
doctrine
The doctrine of after acquired title. So in this scenario, if one of the other siblings passed away, if this investor had a warranty deed from those 2 grandchildren, he would now have a half
No.
of the property.
He'd still only have a third. He'd still only have a third.
Why?
It's
He'd
got
have to have
title
something
vested
signed with one of
already.
the children that's alive.
But if he had,
You like
have-
these tables? we
I
got
like
out?
this. Yes. So you got, here's the owner.
We've got
Oh,
thirds.
that's not a very good.
Yeah.
Got a better one. Oh, thank you.
We've
all right,
got
so-
thirds, so, that
so we got an
third-
owner.
Uh-huh.
They had
3 kids.
3 children.
Yes.
This one's deceased.
Right. 2 kids.
They had 2 kids.
Right.
This investor gets
Quitclaim deed from both.
Quitclaim deed from
So he has
both
a
of these.
third.
So he's got 1/3.
Right.
Now, let's say tomorrow this person passes away. Let's say they had no kids. They're not married.
Oh, okay.
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 Now, with the quitclaim deed,
Now they
He
he
have.
still only has
Yeah.
a third.
That's right, because
But
they
with-
inherited the other third.
But with the
half of
warranty
third.
deed, if he had gotten a warranty deed, he would have a half because of the doctrine of after acquired title, right?
if there's
No.
no interest.
No,
Well,
because this third gets absorbed, right, into this chain and this chain.
So the parent
Right.
died,
Yes.
and then the other person died.
Mm-hmm.
Yeah.
I like it. Look at this, Josiah.
I
You
think
make them think.
you're gonna need if you got quitclaim deeds, you're gonna have to go get new ones.
But if
Well,
you did,
but if you had a warranty deed.
Then after acquired title would work,
Would kick
and
in,
you would end up
Yeah.
with a half instead of a third.
right?
yeah. Look at you, Josiah. Showing
So-
up the attorney.
Sound like a
Okay,
good
so
law
that's-
school exam.
Because we've been doing more of this. We've been buying partial interest from heirs. Because honestly, sometimes I think it's easier for us and for them.
They went
instead
next,
of trying to
and they tied
get-
it up.
And just instead of trying to get 28 people all on the same page, or 14 of the 28 people, or like we were just talking about, trying to get everybody on the same page at the same time, just one at a time, people sell their interest. And somebody was telling me, oh, you got to do quitclaim deed. I was like, no.
No.
Well, the problem is I'm giving you a warranty deed, and I can't really warrant the title today.
Yes, you
At the
can.
moment that
If
I
you
get the
have
quitclaim
facts-
deed, I may be breaching the warranties.
But if you have knowledge of the genealogy, there's not. What are you afraid of warranting?
Well, who's going to? Okay, but you're warranting it's good, so you have the duty to make it good if it's not good, and the
Right.
expense to do that.
Right. Well,
Huh.
do it by agreement.
Well, I'm just saying you got to make sure the person who you're winning a deed from will have to be convinced that that's okay to do that.
Right.
I think in every case so far, people are fine with it because,
Half of them don't know what they're signing anyway.
well, there's that. And then I think we also have some paperwork when we do these self-closings where it's like, look, we're not coming after you for,
We're looking
we
for
understand,
acquired-
we understand you. They're signing an affidavit. I think we're signing an affidavit that's like, I understand you're a partial owner
Right.
of
Right.
this.
or you're getting, but your title's not been perfected,
Yes.
and we're doing
Yeah. And
a
we're,
warranty deed. So when the
And the only
perfection
way-
happens, we get
yes.
And the only way you can take the risk is if they're willing to allow you to fix things after
Yes.
the fact.
Yes.
So
That's even in some of these cases we've done like almost like a JV, I guess, where it's like, okay, we're going to give you some money now. And then if we perfect this, we just did one today, actually, the guy signed. We're giving a small amount of money now. And then I think we have 2 years to cure it. If we don't, then we've agreed we'll deed it back to him. And then the money we gave him, he just gets to keep that.
Okay.
And if we cure it, then we got to give him more money once we cure it.
Well, I think you should be able to make your own deals as long as everybody knows what you're doing. What's
Yeah.
going on? It's great.
Yeah.
It helps the people.
Yeah.
So Josiah, we're short on time. Preach to us. Why should people, or how do people get a hold of you? Number one, and why should they contact you if they feel like they're painted in a corner?
Well, they can get a hold of me. They can email me at josiah@acrevault.com. First name JOSIAH@acrevault.com. Why should they get a hold of me? If they've got vacant land they want to sell for any reason. And then as far as if it's a house, especially if they are a partial owner of a house, maybe their great grandparent owned it and the estate's never been cleaned up and they're interested in selling their just their interest. We're very interested in looking at more deals like that right now. So they should reach out about either of
And
those.
again, people are stuck. What
Yes.
You have either people aren't cooperating or they just don't have the resources to get an
Yeah.
attorney. They're surviving paycheck to paycheck, but they have this interest. They can't cash in on that interest.
Yeah.
You give them an out because you're willing to take that calculated risk.
Yeah.
A lot of investors aren't willing to take that
Yeah.
calculated risk. A lot of investors want to take a package deal that's, I'm not saying it's clean because there's repairs,
Mm-hmm.
but when it comes to the title, they're not willing to take that risk.
Yeah, I think like most, like a lot of the houses we've done this on, it's like we're selling it to somebody who flips houses. It's like we don't flip houses. We're not in the renovation business, but it's like people that are in the renovation business, in my experience, they don't want to get into the
title
curing the title business. So we can all work together in that way.
I just think that you're providing a good service for a lot of people that just are stuck. So if someone's stuck and they need a way out, they can get you by emailing you at josiah@acrevault.com.
Yeah.
That's an easy fix.
Yeah. Yeah.
Well, Rusty, our time is way short. We got just 10 more minutes. I needed to ask you a question about insurance real fast. Not title insurance, but hazard insurance. On a subject to deal, which means that the person is buying the property subject to the existing mortgage, what happens to the hazard insurance that is in place at the time of the acquisition?
Well, considering that the owner is the insured and the buyer may not be listed as an insured, I think it depends on what the insurance product itself says. But here's the thing:
a hazard insurance policy.
You have to have an insurance. You have to have an insured interest, and if you don't own the property anymore, I don't know how that is. But you do have an insured liability because you have a mortgage that you're still on the hook for.
Okay.
So you're not going to get it renewed too easily.
No.
Okay. And the big issue is when it comes time for renewing, you get your own insurance, and then you send it off to the servicer. If they don't look at it, you might be fine. But if they look at it, you might have a problem because now they know there's been a transfer and the
So
loan.
do you believe that the insurance policy that is currently in place on a subject to deal, the buyer buys it, they close, deed transfers, subject to the existing mortgage, that the insurance policy that is in place still protects the lender?
I think
then
that
there was
Wouldn't it? If the lender's a named insured, why wouldn't it protect them?
Is there a cancellation situation on the insurance policy that says if you transfer the property, if you're no longer the owner, your insurance policy is automatically canceled?
I don't know how. I've never done a subject to deal, but isn't it common that people that do them are setting up a trust?
Yes, but even then, the beneficiary is not the insured.
What if you're contacting the insurance company and saying, "Hey, can you please change this to my 123 Main Street land trust?"
If that works, that's great.
Again, I think it comes down to the actual policy itself. Is that policy going to insure the property, or does it? If you no longer have an insured liability or an insurable interest, they cancel it. Because here's the thing: you still have an insurable interest because you're still on the hook for that note.
I agree with you, but it's an interesting dilemma.
Well, again, you're not supposed to do subject to deals.
Why not?
Because there's a do and sell clause in the mortgage.
Okay, but there's inherent risk in everything.
I understand. You're taking that risk.
You're taking that risk.
Yeah.
If somebody has a 3.2% interest rate on a mortgage and they're in the middle of a foreclosure, they got in trouble, and the quickest and easy way out for them is to have somebody just take over the payments, get the back payments current, and start making the payments. Gives them an out, gives them an exit strategy. Again, we're talking, to Josiah. Some people are just paying to the corner because you think about it, Rusty. These people that get into foreclosure, if their home were in a condition that could be sold to a normal buyer, they would have done that. There's a reason why they're in the predicament they are in. It's something wasn't fixed. The roof can't be insured. They don't have the money to fix the roof, right? So they're stuck. So you get an investor comes in and says, "Listen, we'll pay you some money and
we'll fix the roof, get good insurance."
Get insurance and move on down the road and gives them something for instead of getting foreclosed on, right?
Right, but the loan, what makes you think that the lender has to reinstate it every time if they bring it out of foreclosure?
They don't have to.
Okay.
But isn't there protection? Is it the St. Garmain's Act of 1982 or whatever? Doesn't that give protection to homeowners to be able to put the property into a trust?
That's
and then
fine,
if they want to transfer the beneficial interest, they're allowed to do that?
No. See, that's just it. If the property is transferred into a trust,
Yeah.
like the estate planning trust, well, the beneficiaries of the trust are the family member or the settler, right?
Mm-hmm.
I'm the first beneficiary of my revocable living trust,
Mm-hmm.
and then if I die, somebody else will be the beneficiary. Well, that's fine. In fact, if you a devise or a descending, the property devised at death or descends to somebody without a will, that will not cause a dual and sell clause, the standard dual and sell clause to be called.
Right. Okay.
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 Now there are certain mortgage loans that it will, like some of the second mortgage for rehab or ship loans and stuff like that, where the language says
A death will trigger due on sale clause in that.
Now, if typically though, when it does that, if the person that's going to own it lives there, if that's the case, then they I think there's some provisions that allow for it, and it comes down to the words of the document itself.
Okay.
It's not automatic.
Julie, did you look something up for us?
Basically, the buyer has to obtain their own insurance, and the seller's becomes invalid once the sale takes place. However, if I'm reading down here, it says a subject to sale violates the due on sale clause in most mortgages.
That's correct.
Right. So, but the buyer still has to get their own.
I think the insurance goes void.
It will. It won't cover anything.
I think
is
there's
void.
a definite issue there, and I think you might have to read the insurance policy. But again, if
I think insurance policies are pretty standardized.
I understand they have to have their forms approved, but think about it. If I'm the insurer, I'm the underwriter.
Mm-hmm.
Okay, do I want to pay a claim?
No.
So am I looking for any legal reason within my contract not to pay the claim?
Yes.
Mm-hmm.
Who's my duty to?
Yourself.
Shareholders.
My stockholders.
That's right.
Okay.
Yeah.
Now, I think that becomes, people who do dumb things get dumb results.
But it's not dumb, Rusty. Listen.
How are you going to
Subject to transactions
right.
have its purpose in distressed properties, especially. Okay, it really does. And investors who are taking that chance, obviously, you don't want to be an investor on a subject to deal without an exit strategy, right?
Correct.
Okay, you want to have an exit, but it can really help somebody who's in a bind at that moment.
Well, maybe you go get your own insurance, make sure your seller is an additional insured, so their name's still on the policy when the lender
Not a bad
servicer
idea.
gets it.
Not a bad idea.
That way, you're not. They're going to have to be really careful to notice it.
Right.
But and again, as long as you don't do the closing and then 3 weeks later you transfer it to me with a land trust or something,
Right.
that can be fraud. But if we're talking about what you're talking about with somebody
Right.
getting in trouble, then I think you may be able to get away with it at least for a while. But then you got to make sure that you don't ever have to talk to these people on the phone, because you're not going to be able to authenticate.
Well, there's documentation. You can get a limited power of attorney that allows you to do that from the seller. The seller has the seller's benefit is that the payments are being made.
Oh, it helps their credit.
And the seller's benefit is that eventually it should get paid off. Looks a lot better than a foreclosure, Rusty.
Oh, of course it does. And believe
Okay.
me, if it's at 3.5%, it's not going to get it's not wonderful to have out there.
Right. And these investors then can take their cash and capital, fixing the property up, making it marketable so it can be sold.
Correct.
Okay. So the answer is, if you do a subject to deal, you have to get your own insurance.
Well, you don't have to, but you'd be stupid not to. If you want coverage, yes.
If you don't want the mortgage to get, that's a sure way to get that mortgage called due.
Well,
think about the liability.
there's not going to be if there's no claim, nobody's ever really going to know until it gets renewed or not.
I know we're running short on time, but can we have about three more minutes?
You got a minute.
Okay. He gave me the thumbs up.
Yeah.
Think about this scenario real quick. And I like your input too on this, Josiah, to think about this.
thank you.
Scenario. We have a subject to deal. Okay. Seller allows the subject to deal. They're painted on the corner. They need a way out. It wasn't in foreclosure, but they were 6 months behind, and it was about to be.
Okay.
Okay.
Lender. Okay.
Thank you for your comments.
What'd you say? A little under?
No, slow lender.
Slow lender. Oh,
Yeah.
uh-huh.
So we do the transaction. Okay. Buyer's adamant. Lender's already paid for the insurance. The insurance shows them as lost payee. We're not changing that. I'm not getting a new insurance policy. It's not required. I shouldn't have to. I understand that I'm not listed on the policy. I'm willing to take that risk.
Is the seller willing to take the risk?
That's the issue, because if that property burns down and that policy is void, that lender is not going to be covered.
Well, they're not going to.
They're going to come after.
Well, if payments stop getting made, yeah, they're going to after the person who signed the note.
That's right. They're going to come after the person who signs the note. This is what I told. I had one of these subject to deals where and everybody understands the risk. The seller understood the risk. We have disclosures they sign. The buyer is adamant that I don't need to get insurance, is what they were telling me. And I said, there ain't no way in Hades you're going to close this here at my office and not have insurance showing the lender's lost payee as you as the insured. Okay? So I said, ain't no way it's going to happen. And I just want to make sure that I wasn't wrong, because after a while I started thinking about it. I'm like, well, that lender is listed as lost payee on the policy. But I think the insurance policy goes void after the conveyance. I don't think there's a provision in there. And if that house burnt down to the ground, buyer walks away.
The seller's still on the hook for the note.
Seller has no interest in the property. Seller doesn't own anything.
He owns the liability of the note.
But he has the liability of the note. And so if they foreclose and they have to foreclose, they only get $60,000 because it's a vacant, but there's a $300,000 deficit. Who are they going after?
The person who probably doesn't have any money. That's who they're going after.
That's right. So the point is,
it's a problem.
It's a problem.
People
You got to
need to
get
take, people
you
need
gotta
to
get
do the right
insurance.
thing.
Right.
Okay. And it doesn't matter until it does. Okay. And when it does, you can't fix it.
That's true.
You don't need life insurance until somebody dies. And when that happens, it's too late. And you can't get
Listen.
health insurance after you're sick.
If this was one of those deals where the investor wanted to take the risk with no insurance and there was nobody else that could be harmed by it, then I would say, knock yourself out. You know what the risks are. But they were actually putting the seller at risk, which they don't have authorization to do.
Well, I guess the seller could accept that risk if they knew what they were doing.
Seller does not accept that risk.
Well, if the
Make
seller,
sure I told the seller about the
okay,
risk.
if the seller says that's
Because
not
I needed somebody to
acceptable-
back me up on this, because
Well, but here's the thing.
they're like, you're the title guy. You can't tell us what to do. I'm like, well, this is what the seller wants. Right, seller? This is what you want, right?
Well, I would say just sign this piece of paper that says I was informed of
Yeah.
this.
So,
I was told to do A. I'm doing B. I am stupid. Sign here.
yes. All right.
Okay.
Well, as always, Rest, appreciate you being here. Josiah, how do people find you? Seriously. So Josiah at
AcreVault.com.
AcreVault.com.
ACRE. Vault like a bank vault. Acre like an acre of land. Vault like a bank vault.
AcreVault.com.
Yeah.
Yeah. I really appreciate you being on the show with
Thank
us.
you for asking me to be here.
Yeah, it's awesome.
This
There's
is
so many
well
more
worth the
things.
drive.
Oh, yeah.
Yeah.
There's so many more things to talk about, too.
Oh, I mean, I could talk about this stuff and listen to you guys talk about this stuff all day. I just nerd out over all of this.
Well,
Yeah, I love it.
we love having you. So thank you very much for being here with us. This has
Thank
been
you.
Land Title Talk. We appreciate you listening in. We're going to be back next week, right?
Yes.
All right. Next week. We'll talk to you then.